copy of the invention, which essentially is trying to steal the invention, or an invention which is similar and related but not necessarily the same. When something like that happens, what this little timeline is trying to show, say you present at a conference and you're party B, right? You still have up to a year to file your patent application here at the right-hand side. If someone who happens to have been at that conference sees your disclosure and also then at some intermediate point in time has their own disclosure, there's the possibility that that can be held against you, even though it's not your disclosure. It may be very close to your work. There's very certain situations in which that may or may not be held against you. So in a case where this second party A, for instance, is just directly copying exactly what you have done and what you have described publicly, you're able to get rid of that and you don't have to worry about that activity by a second party. The problem arises when this second party, which is disclosing something, is doing it in a field that's related to the invention, but not exactly the invention, and the subject matter that's in that intermediate disclosure can be enough to nullify the patentability of your own actual invention, in the sense that it may have been obvious in view of what this other person had done, even though it wasn't exactly what you had done. And so one of the things that you need to be aware of, and this is more going towards the university administrators who are deciding whether or not to file and when to file, it's very risky to try to rely on an initial disclosure, say again in a journal or at a meeting. It's risky to try to rely on that disclosure as a way to protect your rights. It's important, even if there's been disclosure, it's still important to file a patent application as soon as possible if the technology is valuable. And again, that stems from the uncertainty in how good this exception is. It could be very limited, and it could essentially open up the opportunity for someone else to spoil the rights to that invention. So at the same time, if you're an inventor, if you're a student or a professor or faculty member working with this technology, and you're involved in this patent process, it's equally important to be aware of this limitation. And so if a decision is made to actually file a patent application on behalf of the university, it's important that you act in a timely fashion and try to get things into the university or to the patent attorney as soon as possible, so that we can try to avoid this type of timeline where we're losing patent rights. So there are a lot of details in different fact scenarios that can stem from this type of timeline, and we can talk about those if anyone's interested. But I'll move on. But this is probably the most important thing that you can take from this, is that you need to be very careful about relying on your own disclosure as a means to protect your invention. It still has been in the past, and it still is the best course to file a patent application before any type of disclosure. So, I think I mentioned this at the beginning. Another aspect of the existing patent system is that we have the first to invent system, meaning that you couldn't legitimately invent something independently from someone else, and then if that becomes a conflict in terms of two applications or two patents, we have an existing system called interference to try to determine who is the actual first inventor. Well, as I mentioned, that's gone now. The emphasis on when someone invented anything is no longer relevant. However, it is possible that two people may have independently invented something and filed patent applications on that. In that situation, generally the person who files first is the person who is entitled to the patent. However, in a limited set of circumstances, it's called derivation. That essentially means stealing of the invention. If you can show that even though you were the second person to file a patent application, but you can show that the first person who actually filed the patent application derived or stole the invention from your inventor, then that's an opportunity to nonetheless have the patent rights there. Now, the proceedings for going through this, they're very consuming in terms of, it's basically a court proceeding, which is a very complex and expensive proposition that generally you wouldn't want to be involved in on the university side just because of its cost. So the main message here is that this is something that, of course, you want to avoid. The way to avoid this, of course, is to file on one side is to file your application sooner than later. And the other thing you want to avoid, too, is you don't want to be on the other side where you've got a filed application and someone claims that you derived it from that other person. You want to be able to demonstrate that you've independently invented the subject matter yourself. And so what's currently good practice remains good practice both for technical scientific reasons but also for patent reasons. And so good laboratory record keeping, you still want to do this. It won't necessarily demonstrate first invention, but it can demonstrate independent invention, which can be important. So that's something to continue to do. Okay? So you've probably gathered this, but the main incentives that anybody has, whether they're a university or otherwise, is that you want to file early and often, and that will maximize the protection and it will minimize the risk that someone else independently files on something which is similar to or the same as your invention. But of course, you have to balance real-world constraints to arrive at a good decision. And you have to balance things like the cost of filing a patent application, how quickly can the application be filed, and how thoroughly can the application be drafted. You have to consider all of these things. It's not just whether or not you've got something which is novel and non-obvious over the prior art. It also depends on how thoroughly you describe the invention when you file your patent application. And so one of the ways to do this, and this is a strategy that is not normally used under the current law, but it would be possible to sort of minimize your risks, hedge your bets with the new system to file multiple provisional applications on the same technology, with the idea being that each one is an incremental improvement in terms of the level of disclosure that it contains. And so this is not necessarily something from that necessarily involves the inventors. It more involves the attorneys and the university administrators who are making the decisions on what level of protection to seek. And so we can talk a little bit about that type of strategy. And so I'll try not to spend too much time on this, but it's important. The general case in the university scenarios, you'll have a patentable invention. It has some generic application, and I'd call that XY, capital X, capital Y, where those are just, whatever those are, it doesn't matter. It's just two inventive elements, a new combination that is patentable, it's new, it's not obvious over the prior art. Well, what usually happens, especially in a university setting, is someone will be working in a lab, and they'll reduce to practice, actually make some species of that invention. And then they'll write up a detailed manuscript or a presentation for a meeting, and that will be a very thorough description of how to do one thing within the generic invention. Well, if we just take that description of this species of the invention, and file a patent application, we can do this very quickly. Just take the invention disclosure, put a cover sheet on it, which is the patent office requirement for filing a minimum requirement for filing a patent application. We can file that, and we can do that very quickly. Now, what we'll see in the next slide is that there's sort of limited value to do that, but there is some value. Sort of an intermediate step that we can take is we can still take that base disclosure that's provided by the inventor, but we can go ahead and we can add some value to that on the side of the patent attorney. And we can write some claims where the patent attorney essentially tries to identify, well, I see what the specific invention is that the inventors have made. Now, how do I make that a little bit more generic in terms of what's the broader application and what are some alternatives to the particular species that the inventor had described. And that's what I call this second level of application. And of course, if we go to the third level, that's essentially a full, complete application where we've got a full written description of the invention, the inventor's original examples that support the invention, and claims that fully describe and cover the inventive concepts. So that would be the third level of completeness.